Hi, my name's Phil. I like to talk about politics, and it looks like there's going to be another little pre-weekend video because today was a little bit more exciting than I thought. We had the full hearing in the Court of Session in Scotland, which is a Brexit-related case specifically to try and get a court order to completely nail down the Prime Minister such that on October the 19th, he definitely has to sign the letter requesting the extension if he hasn't got Parliament to agree to either a no deal or a deal that has also been agreed with the European Council. But first, if you find yourself enjoying the video, then please click the like button and subscribe to the channel. So I sort of thought there was a little preliminary hearing first, then a more full one next week. Turns out it was all today. Things brought forward again. Insert regular comment now that this will be much easier once this is my daytime job as well. But yeah, so it started off, the government's initial ploy was to try and say, oh, we don't really need a judgment down to it. It's days away. And by the time October the 19th rolls around, there'll still be plenty of time. Obviously, this didn't wash with the petitioners who were saying, well, there won't actually be very much time at all because it's not just a case of getting the Prime Minister to sign the letter and get it sent off. We need the EU Council to deliberate, even though we hope they'll do that in advance, and then come back with their counter offer or agreement, and then it needs to come back to Parliament so that they can agree. There's not very much time to do all this. So the government sort of abandoned that one a little bit. And as part of the proceedings, and this is the real big news here, and this is what you'll have seen reported everywhere, as part of the proceedings, the government basically looked like it was committing to fully comply with the Benn Act. Now remember this, Boris Johnson has been saying, of course we'll comply with the law, but I will not sign this letter. That's what he said. This is what the government presented to court. Let's find it. There it is. So, this is part of their submissions. The petition and the 2009 Act, 19 Act, are referred to for their whole terms beyond which no admission is made. Quadultra, I'm not very good at Latin or legal speak. Denied save insofar as coinciding herewith, explained and averred that the Prime Minister accepts in relation to the 2019 Act. So, he accepts the following 3 points. A, that subject to section 1.5 in the event that neither of the conditions set out in section 1.1 and 1.2 is satisfied, what those conditions are, by the way, are if Parliament votes to leave the EU without a deal, or if Parliament votes to leave with a deal that has been agreed with the EU. If either of those two things happen, then he's not constrained. So that just says what that is. But if those two things, if neither of them are satisfied, he will send a letter in the form set out in the schedule by no later than 19th of October 2019, blah, 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 blah. Because when I was first seeing it reported that he said he's going to send an extension letter, I was thinking, he's got to send the extension letter, the one that's laid out in this act. So he is promising to do, well, the government are promising to do that. More on that in a minute. B, the other thing the government accepts, that subject to section 1.5 in the event that the European Council decides to agree to any extension for the period specified in the letter, which is the end of January 2020, he is obliged immediately to notify the President of the European Council that the United Kingdom agrees to that extension. So if the European Council agree with the extension that's been requested, he has to agree. He's saying that. C, that subject to section 1.5 in the event that the European Council decides to agree to an extension until a date other than that date specified in the letter, he is obliged to notify the President of the European Council within the period specified in section 3.2, which is 2 days, that the United Kingdom agrees to that extension, this obligation being disapplied if the House of Commons has decided not to pass a motion of the kind specified in section 3.3. So what he's basically saying, this is full compliance and it's quite clear. He is going to send the letter and, when the offer comes back of an extension, he is going to accept it. And if it's a different extension to the one requested, he's going to put it to Parliament for a vote within 2 days, which is exactly what the Act requires him to do. However, but you might be thinking at this point, well, this is a bit strange then, isn't it? This is him just climbing down. But is it? Because here's the problem. First of all, Downing Street sources. Now, in this, normally when the news reports Downing Street sources, we sort of accept it because it basically means someone who doesn't want to be identified, all right, whatever. In this particular case, it's like worthless because we're talking about a legal situation here. Unless they're going to say it's someone like the Attorney General or someone who's an expert in law, it's absolutely worthless, or a government lawyer. But they kept saying things like, yes, of course we're going to comply with the law, but we are still leaving on October the 31st. How's that then? But in the court case itself, this is what really matters, not what people... I mean, like I was saying on Twitter, in this particular case, Downing Street source could be anyone. Could be the cat, could be Dominic Cummings, could be whoever's in charge of tea and biscuits in Downing Street, could be the police officer on guard outside, could be anyone. It's irrelevant. In court, the government's QC stood up, and the judge was basically saying, okay, this is great that the government are confirming that the Prime Minister will sign this letter. But what we'd really like is to be sure that this is definitely the Prime Minister who's committing to this. What we could really do with is a sworn statement to that effect. And the government's QC was going, I don't think we really need that. To which the judge was basically responding, I'm paraphrasing here, it is normal practice in a situation like this to have a sworn statement. And the QC was going, I don't really see what good it would do. The judge responded, well, it would put the petitioners' minds at rest. No, we're not going to do that. At which point the judge had to remark, well, that's a shame. And it will have to form part of his judgment. The fact that the government look like they are clearly saying, of course we are going to comply fully with the law. And they've even set out in detail their understanding of the law. And it's perfectly the same as my understanding and presumably the judge's understanding of the law. All seems fine. What's the harm, therefore, in putting a little signature there? Unless, of course, and this is the only conclusion you can ever draw in a court case where you say a thing, you make a statement, but you're not willing to sign it as a sworn affidavit, the only conclusion a court can ever make is you're not being fully honest with us. And this is the madness of it. This is exactly what they did with the Supreme Court case into prorogation. On that occasion, the judges were saying there should be a sworn statement here. And the government's lawyers were saying, well, there's not going to be one. To which they said, and that affected the judgment. Because then they can't trust the government if the government's not willing to sign that this is the true statement. So the only conclusion you can draw is that, because remember, you don't normally go to jail for lying, but you can if you sign a sworn affidavit. But what's interesting in this particular case is, earlier on the judge was saying that given that the government have provided this assurance, even if it's not a signed statement, it's come from the government. It will be deemed that the Prime Minister has given his authority to this. The judge did suggest that if Boris Johnson on October 19th is compelled by the Benn Act to sign this letter, and he doesn't, the fact that he's made this submission to the court could, without any further court order, mean he's held in contempt of court. Now, just to remind people what that can mean is, that can mean you send round a police van, hoik him out of number 10 and chuck him in the back of it. Contempt of court can easily mean taken into custody and left there until you decide to stop being contemptuous of court and to do what you're told. So that's a consequence straight away. Obviously, what the petitioners want is a court order. Now, that's not going to happen until Monday. The judge will announce the verdict on Monday. They may or may not give a court order. I don't know that. What I do know is that whatever happens on Monday, one side, either the petitioners or the government, will not be happy with it, and they will immediately appeal. And of course, that means it goes back to the Supreme Court. This is all fine. Presumably that will be set up fairly quickly. Remember, we only need this court order before October the 19th. It would be better if Parliament did something more positive by then. But in the meantime, in terms of legal remedies, whatever the legal remedy ends up being, it's altogether preferable if we have it by October the 19th. And the judgment comes out on Monday. Presumably a full judgment or whatever will follow a couple of days later, if not actually on the Monday. In which case, the appeal can be heard even at the start of the following week's fine. That's enough time to get it done by October the 19th. In which case, although we wouldn't give that much time, better off if it's towards the end of next week, I suppose, isn't it? I'm sure they'll be ready to go. But in that, the Supreme Court ultimately will have to have the final say again, because like I say, whoever loses effectively or who's not entirely happy is going to appeal to the Supreme Court. So that's where it's going to end up going. And what we really want to know is exactly what are the consequences for Boris Johnson if he fails to comply with the Benn Act. Because the situation could easily be, I was saying this on Twitter, that Boris Johnson disobeys the law, but he actually thinks he's not disobeying the law, that he actually thinks he's found a loophole. He hasn't. There won't be one. But that's what he may think. So anyway, those are the rather explosive events for today, and the key one being that, and this is how it's been reported everywhere, regardless of whether Boris Johnson intends to or not, he has submitted papers that say, of course, I'm going to sign that letter. That is the news of today. I hope you have a good weekend. I hope you find the video interesting. If you'd like to support the channel further, then please click on the Patreon link for details. And until next time, I'll see you later.